Hello friends, Uniform Civil Code is the hotly debated issue and I am going to decipher the Uniform Civil Code. Before we start, it is important that we take a look at the Constitution with respect to Uniform Civil Code. Under the Constitution, under Part 4, which deals with Directive Principles of a State Policy, Article 44 provides that the state shall endeavor to secure for its citizens uniform civil code throughout the territory of India. The Constitution uses the expression uniform civil code. However, this expression is not defined under the Constitution, and therefore we'll have to understand by its cognate meaning uniform civil code. The civil code is generally understood a code relating to civil rights of individuals, and the civil rights encompasses relating to the personal law, the rights relating to marriage and divorce, inheritance, succession, adoption, maintenance, etc. Therefore, what is generally understood from Uniform Civil Code is a civil code relating to the family matters, the personal laws of the individuals, and which is uniformly applied throughout the territory of India. This is what is generally understood. What is important here is the part 4 of the Directive Principles State Policy is a direction given to the state to make legislation. But however, the principles or the directions under this part 4 is not enforceable under any court of law. That is only an endeavor the state has to make while legislating in the areas of Uniform Civil Code. There have been cases that relating to Uniform Civil Code. The first case of the Supreme Court was the Shah Banu case of 1985. Thereafter, it was Sarla Mudgal case of 95. Further, there was a case of Lily Thomas, and the final case was in the year 2017 of Shaira Banu. Now, if you look at the judgments of the Supreme Court in all these cases, especially relating to the Sarla Mudgal case, this refers to there has always had been observation of the Supreme Court that the state shall endeavor towards a uniform civil code. But however, the judgment of Sarla Mudgal and Lily Thomas are based on factual position that there were 4 petitioners and 4 writ petitions were filed, and all those were Hindu husbands, and these Hindu husbands during the subsistence of their first marriage had entered into a second marriage with a woman, and to embrace that they have embraced the religion Islam so that they would be able to marry again, and under the sense they have changed the religion, so the first marriage would get dissolved automatically because the husband has changed the religion, and they were all Hindus. However, it was held that the change of religion for the mere purpose of solemnizing second marriage during the subsistence of the first marriage is not valid, and therefore the provisions of IPC 494, which deals with bigamy, would be attracted therein. And there has only been an observation and obiter dicta from the Supreme Court that the state should endeavor towards Uniform Civil Code. That is what the judgment that we have. 85 Shah Banu judgment related to maintenance, and the 2017 judgment, which is Shaira Banu, is related to the practice of triple tilak. So the triple tilak pronouncement by a husband, which is known as the popularly known as the instant talak, it was held by the Supreme Court that this practice is not valid, and therefore this practice of triple talak has been done away with. But while we talk about the Uniform Civil Code, the Uniform Civil Code encompasses a broader horizon, and the judgment that we have dealt with relates to the aspects of the second marriage during the subsistence of the first marriage, or to the maintenance, and to the malefic practice or undesirable practice, if I may say so, about the triple talaq. But the area of Uniform Civil Code is much bigger. Most importantly, under the constitutional scheme, especially Article 25 and Article 26, which deals with religious freedom and grants to every citizen the right to profess any religion or practice or propagate any religion, along with Article 26 to right to manage the legal affairs, has always come into play about the Uniform Civil Code. And in a country which has diverse religious beliefs and religious practices, it is very difficult or a Herculean task to enforce the Uniform Civil Code, because people of different religions, different religious beliefs and practices, to assimilate them and to bring them on a common platform is a great challenge. The attempts of the Uniform Civil Code, and moreover, when we talk about the Uniform Civil Code, the other challenges are there. In the Constitution, there are certain categories of persons who have been rather granted exemption, in the sense that the personal laws and the customary law of such people cannot be infringed upon through any legislation. And especially the state of Mizoram and the state of Nagaland, under Part 21 of the Constitution, have been granted this exemption. So their personal laws, their customary rights, their religious beliefs and social practices cannot be encroached upon by any legislation. So there in the Constitution itself carves out the exception for the Uniform Civil Code. The question is, Uniform Civil Code, implementing Uniform Civil Code in India is a great challenge. And even if the state, if the parliament enacts any law pertaining to the Uniform Civil Code, that law itself would become the subject matter of judicial review, and the constitutionality of that law, Uniform Civil Code, would be open to challenges in the Supreme Court, because it would be making an encroachment on the religious freedom, on the religious beliefs and the practices of the diversity in India. And if the legislature, the Parliament of India, really intends to bring Uniform Civil Code, then making a legislation, a statute on Uniform Civil Code, in my view, would not serve the purpose. What is important, because the moment the law on Uniform Civil Code is enacted, that would be open to challenges on the grounds of constitutionality in the Supreme Court. Therefore, in order to bring this Uniform Civil Code into practice, the first step which is required to be initiated is making suitable amendment in the Constitution of India itself, whereby the Constitution recognizes. However, this may sound different, because you may ask that the Constitution already provides for Uniform Civil Code. But as I have already mentioned, the provisions relating to Uniform Civil Code is contained in Part 4 of the Constitution, which is Directive Principles of State Policy, and that provision cannot be enforced by any court of law. And therefore, in my humble submission, it is imperative that the Parliament makes a constitutional amendment bringing out or making room for Uniform Civil Code, which says that irrespective of, regardless of the religious beliefs and social practices, the Uniform Civil Code will be the common civil code for all the citizens of India, and that may give room for legislative enactment of the Uniform Civil Code. And in such an event, if the legislation relating to Uniform Civil Code is enacted, the same may also become a matter of subject matter of judicial review and scrutiny, but that would be protected because that law would be made subsequent to suitable amendments in the Constitution, which would lay the foundation for Uniform Civil Code. Now coming specifically on the Uniform Civil Code, there is one state in India, which is the state of Uttarakhand, which has enacted the Uniform Civil Code in 2024. It is important to decipher that Uniform Civil Code. First of all, Section 2 of the Uttarakhand Uniform Civil Code provides that the code is not applicable to scheduled tribes and to persons who are covered under Part 21 of the Constitution, which I have already discussed, that is the state of Mizoram and the state of Nagaland. So they cannot be on that. So there itself, it cannot be said to be uniform. Further, the Uniform Civil Code of Uttarakhand is basically divided into three parts. Part 1 deals with marriage and divorce. And if you look at the provisions relating to marriage and divorce, that Part 1 is substantially a replica of the Hindu Marriage Act. Part 2 deals with succession, intestate succession and testamentary succession. The provisions relating to intestate succession is again a replica of the Hindu Succession Act, and the chapters relating to testamentary succession is a replica of the Indian Succession Act. Part 3 deals with live-in relationships. So Part 3 regulates the live-in relationships, and it gives legitimacy to child begotten out of the live-in relationship. So that is what, in a summary, the contents of the so-called Uniform Civil Code of Uttarakhand. Even the conditions of marriage, there is a requirement of the parties to marriage, the man and the woman, should not be within the degrees of prohibited relationship. Now, Schedule 1 of this code provides the names of the relatives and the people who are within the degrees of prohibited relationship. But the list 1 and list 2 of Schedule 1 encompasses, but that may not be appropriate because of the diverse culture that we have in India. Every religious person or every religious belief and social practice have their own set of norms which encompasses within the degrees of prohibited relationship, and therefore these are all matters which are subject to judicial review and challenges. The nomenclature, the Uniform Civil Code Uttarakhand, does not necessarily mean describe the character of the statute. It doesn't. Well, if we make a dive into the provisions of this, it is only a dream to say that Uttarakhand state has a uniform civil code, but in reality, the situation, and if you look at the provisions of the Uniform Civil Code, are entirely different. It, in all probability and in all fairness, cannot be described that it is a Uniform Civil Code of Uttarakhand. If you find the video's contents useful, please like and subscribe to my channel. Thank you.